Well, here is where, although the student loans are not priority debts, so they don't have to be paid in full, you might be able to work something out so that there's a higher percentage going to the student lender than to the other general unsecured creditors. Now, this is a little counterintuitive because generally speaking, you're not supposed to discriminate unfairly against a particular creditor or particular class of creditor in a Chapter 13 plan. So, if you have a student loan, you can argue that since the interest does accrue on that student loan while you're in Chapter 13, that perhaps that higher percentage of your plan payments should be going to the student lender than to the other general unsecured creditors. You're going to have to convince, most importantly, the Chapter 13 trustee of this. And if you can, then generally the bankruptcy judge appointed to the case will probably go along with whatever the recommendation is of the Chapter 13 trustee. So you might have to come up with some sort of analysis, maybe a spreadsheet showing, well, this is how much the interest is, and therefore, if all I'm doing is paying on the balance without taking into consideration the interest accrual, this student lender is going to be getting less as a percentage on the underlying debt than the other unsecured creditors. So they should get a little bit of a premium based on the interest accrual. If you're above the debt ceilings in Chapter 13, you're ineligible for Chapter 13, and that's when we put somebody into Chapter 11. You can deal with student loans in a Chapter 11 just as you would in a Chapter 13. The one drawback is Chapter 11 is very complicated, so it's concomitantly very expensive. So as a result, we tend to try to get somebody into Chapter 13. And one strategy that sometimes can work if you're just a little bit above the debt ceiling is to pay down the debts enough so that you can qualify for Chapter 13, because it is a considerably less expensive chapter than Chapter 11.